So, Adi, we're online, we're live. So, but you have to introduce yourself first. Whatever, how much ever you want to talk about yourself.
Sure. Thank you very much, Vikram, for the invitation. I'll introduce myself just by saying that my name is Adi Gavrila. The full name is Constantin Adi Gavrila. I am a mediator. I'm a full-time mediator. By training, I am an engineer and a lawyer. I have been managing the mediation center established by the Romanian Ministry of Justice some 19 years ago in Romania. That pilot center became the laboratory for the mediation law that was then drafted and published and adopted by the Romanian Parliament and published back in 2006. In the past 7 to 8 years, this is what I do full time. This is my, activity, either domestic practice or international practice. It's all mediation. That's it, not much. I like to train every now and then, and I do consultancy, ADR consultancy work as well with Leonardo D'Urso, my partner at the ADR Center, for international projects, international ADR development projects. So in a nutshell, this is what I do. I try to stay honest with domestic practice, as I said, all those, civil cases, family cases, commercial cases, one-on-one, that interpersonal conflicts that would help you stay true to your skills and then keep them alive, so that then whenever you have more complex, more cases with more parties, with multiple parties, with multiple issues, and so on and so forth, you'll be able to perform, just to keep it simple. That's it. A mediator. Otherwise, I am very excited to be here to speak about mediation in our culture and traditions. I like the title. Basically, you can speak about anything you want. It's all about culture and traditions, isn't it? I chose to present a few slides, if that's fine with you, Vikram, about what's going on in the world with the implementation of ADR policies in different jurisdictions. Because at the end of the day, we can look at the past, and we have to look at the past in order to understand, what we need to do in the future, and so on and so forth. We know that in the past, there are all those traditional mechanisms and trusted community members that communities already go to whenever they have a dispute. They're there. Those practices are there. They have lots of benefits. They are used. They are trusted. The people are trusted, and so on and so forth. But that's not mediation. That is not mediation. That's they are different processes, different forms, different. I would say that those mediators or interveners usually have some sort of authority within their communities, maybe even power to enforce the process and its outcomes. Sometimes they can have the authority to enforce a solution if the parties are not successful. So it's all about the hybrid formula that may differ from one place to another. What we're trying to see here, because I'm looking at the title, it's mediation in our culture and traditions, not dispute resolution in our culture and traditions. So that's the key word is mediation. And what do we mean by that word? Something that our sector is still contemplating for many, many years, isn't it? I think there is a book, a variegated landscape of dispute resolution written by our friend Manon Schoenville that identifies some 40 definitions different definitions of mediation. Like, and they're like legal in the mediation laws and so on and so forth. So the world is still thinking what mediation is. Anyway, I would like to have a pragmatic presentation over how what could be good practice in terms of ADR policy and mediation policy, so that we actually see an effective enabling environment for mediation and ADR. And now, because I am based in Romania, and Romania is a member of the European Union, and geographically is in Europe, I will focus on the data that we have around us. And yeah, we'll say more when we get there. Would that be okay, Vikram? Just to go ahead and present.
Oh, perfect.
Yes, thank you. As you see, I'm trying to get you into the conversation.
But let me tell people that Adi is not too well. So if his voice goes down a little bit, it's only because he's not well and he's still doing this presentation, which I'm really happy.
Thank you very much, Vikram. We'll let you know if we need to stop. Okay, so as I said, I am working with Leonardo D'Urso as part of ADR Center, and we do a lot of international projects. And the organization is called ADR Center. It's based in Italy. I am based in Romania, therefore I lead the ADR Center Romania. But the whole discussion now is that it's not anymore a matter of opinion what is effective policy. It's a matter of data. We have to look at the data, and we have to actually really develop a methodology to really interpret the data in order to decide what's effective and what's not too effective, or wishful thinking. So if we go to a sample of 100 disputes, and some of these disputes are manifest, some are still brewing under the surface like a volcano, they're not there yet. So let's say that 30 are still brewing under the surface, and 60 are visible. Let's say half get to be settled by parties themselves, and half they don't settle. Well, the default option, as we all know it, is that they go to litigation. Many of them, and that's actually that may be the case everywhere, including in the US. We'll be speaking about different jurisdictions, Vikram, and they still go first to litigation, many of them. So that's still a default choice in many jurisdictions, even where ADR and mediation is actually really are mainstream. So litigation is still the first step. So the issue is that, of course, in litigation, they can be settled, which is important. And I know that 90+%, for example, in the US, of civil and commercial cases get to be settled, even once they litigation is initiated. So we're going to park that example, that let's say those jurisdictions, and we're going to focus on jurisdictions like mine and the ones around mine, where actually litigation is actually capturing everything. Maybe less than 1 or 5% are settling once they reach litigation. I'm not sure how the situation is in India or in other places, but I will tell you for a fact that this is the situation in Romania for sure, if not in many other countries around me. So the issue is that you have 40 left for litigation, and new conflicts will be created because of those litigated cases. You see, there is a litigation case that creates a new conflict. That's the concept. And that is because litigation is not ending the conflict. It's bringing a resolution to the conflict. But not only that is not ending it, it may increase its amplitude and it may create new conflicts. So therefore, you have a jurisdiction where cases get to the courts, and that creates more conflict. So we have to take a step back and see what is that we can do to actually prevent this from happening, because that's Vikram and folks watching, that's like a plane flying like this to me. And I'm not sure how much and for how long planes can fly like this. That's the problem. So if we take a step back, we look at the spectrum of dispute resolution, where we have avoidance and interest level, decision making, and rights level decision making, and power, and so on. We see different, processes or approaches like minimization and misdirection that are related to avoidance, and negotiation related to the interest level, and of course litigation on arbitration related to the rights level, and of course protests, violence, enforcement related to the power-based level. Mediation fits here. Question is, can we include it in a sustainable way in the institutions that are part of the entire system, so that then it's not like something that was imported, but it's something that becomes of an integral part of the whole. So that's the question, that's what many countries have been struggling with. And just to do a little bit of history, it's been a process, it's been a journey, starting, for the modern mediation, starting with the 70s, the Pound Conference, and all those key moments in the history of ADR and modern mediation. New providers like GEMS, AAA, and others that have started looking at things from a very professional perspective. Okay, let's provide the service that the market needs, and so on and so forth. So it's slow and constant growth of mediation. ADR Act was introduced in the US, so it was organic, but to some extent the need for policy was there. And that's why, Europe, as you see, in the early 2000s, even late 90s, there were some recommendations in the European Union's, framework. And the EU directive, of course, in 2008, transposition of this directive in all member states. So all these things relate to the fact that it's bottom up is not enough. You need some top down, you need some policy, some level of regulation. And of course, that is, we can debate until tomorrow. First, if any level of regulation is needed, and second, to what extent regulation becomes barriers, and actually it's preventing development, and so on and so forth. But that's a different conversation. Bottom line is that in 2013, the Italian law on mediation was adopted, the new version of the Italian law of mediation, because the previous one was a full mandatory version. And this new version refers to the first meeting only, that is mandatory, of both parties, or all parties, and the mediator, and their lawyers, and the mediator. And we'll go back to that model in a second. But then other countries like Turkey or Greece, or even other countries like I think Serbia is looking at the Italian model, Azerbaijan is looking at the Italian model, and others as well. I know for sure that Romania is looking at the Italian model as well. So question is, what's next, and where are we going next, and what's effective? So there is a cycle that we see. It's invisible, it's not too visible, but it's there. And that refers to developing effective mediation public policies. You see, one has to start, no, let me say something else first. There are two stages in developing public policy. The first stage refers to the technical development. So you really need people who really understand mediation, that, that need to get together and start thinking and then putting things together and drafting policy, an effective policy. Really look at the data, compare different options, different models, and then put down the ups and downs, the benefits and the risks and all that related to each option, and propose to governments, in the context of this map of options, we're going to propose this option, and that's it. And these are our arguments. So that's the first technical development stage. The second stage is called the political dialogue. When you take this and you start discussing it with stakeholders, and you see what they're thinking, what are their thoughts, and you try to, it's a mediation. Basically, you bring them all together and you try to get them to reflect on that proposal, and try to improve it as you go along, so that when you finalize this political dialogue stage, you not only have a piece of policy that is consistent with best international practices or good international practices, you have a proposal that is that integrates the needs and interests of local stakeholders and, more important, their support and ownership. In which case, just like in any mediation, right, we're putting our mediation hats now. They would just, just not only be happy with it, but will support it, will be part of its implementation. And that's key. Because I'll tell you what happened in Romania, because the lawyers weren't, first of all, they were never really asked about, the mediation legal framework. Then, of course, they didn't want to be part of its implementation, and they were not too supportive. And whenever their clients were asking, they were saying, no, that's just like, don't worry about it. We'll do whatever we can to comply, but then you don't have to really engage. So question is, how do we achieve both sides, the technical development as well as the political dialogue? So see, now looking back to this slide, there are four, checkpoints. First, you have to look at the international standards. You have to then adapt them to the local context. And this is where you need to engage the stakeholders. And as I said, to facilitate that dialogue. And then it's probably the most important part, which is how you implement it, how you test and look back, test, monitor, and look back, and readjust. That's key. It's really, really important, because the fine tuning is actually what creates the final product. And finally, you have to keep an eye on new developments and always think about new things that can be incorporated. And then again, so there are countries that did this circle for a number of times. It's a constant development process, as it's written on the slide. So each country, we have to really understand where we are, which part we actually covered, and which we didn't, and where we need to go. In a nutshell, to be effective, a mediation policy needs to ensure high quality mediation services, and that's all in the accreditation and standards and monitoring of quality, and that we can do with online platforms and so on. You need providers like institutions. In Romania, there used to be more than 10,000-12,000 mediators, and almost the same number of providers, because the legislation was created in a way such that each mediator can establish their own provider. And you had these little kitchenette mediation firms, like maybe in one bedroom apartment, and the waiting hall would be in the kitchen, and people would just, that's the message that is sent out to the public. That's what mediation is. And just to give you an example, in Italy, if I'm not mistaken, you need 5 mediators at minimum in a provider. So that's, you see the difference? It's like the institutions. What message are you sending out to the society about mediation? Because if out of the 10 or 12,000, you have 11,500 really, really small, I'm going to use a word that is not correct, but I'm going to use it for the sake of example, garage mediation firms, then that's what society is going to see. And of course, the society is going to see mediation. I don't know. I don't know about that, so that's, how do you create the institutions that, will actually send messages that mediation is a high quality service and so on and so forth. It's really important, the professional mediation service. But that's not enough. Supply is not enough. It's been attempted in many countries, let's keep on working on those mediators, but that became more and more. For example, in Romania, there are 1,000 or 2,000 mediators left now, because in the past 8 years, it's been almost next to nothing, that is because of a constitutional court decision back in 2013 or 14. And the question is that you need in order to be effective, a policy needs to be able to increase the recourse to mediation as well. And that's what we are observing all over the world in the conversation about, yes, I'm going to say it, mandatory mediation. That question is, what is mandatory? Is it the whole process? Is it just the first meeting? What's the sanction if you don't attend the first meeting? So these are key questions, and I'm going to just spend 1 minute discussing about that. Just to present the very simple structure of the initial mediation session, the Italian model, you have a request submitted to a mediation center that invites the other party. If not both parties are requesting this first session, the other party is free to decline. Otherwise, if they accept to attend the first meeting, the requesting party and the invited party sit down with the mediator, or with a mediator appointed by the mediation center that received the request. So see, the request is not submitted to the mediator, him or herself, is submitted to the mediation center. And then that meeting could be like 15 minutes, 30 minutes, 1 hour, 5 minutes, 10 minutes. It depends. At the end of the day, the parties get to voluntarily agree to engage in mediation if they wanted to. Otherwise, that ends then and there. So you see, the mediation is still voluntary. It's just this first meeting that is merely a sample station or a tasting station where parties get to sit down and to really get a little bit into the substance. Vikram, what was you had the idea of initiating this, you're the requesting party, and your brother is here. Can I ask you why? Why did you think that this could be an idea? What did you think that could be beneficial for you and your brother? Blah, 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 and all that. And then your brother will be all eyes and ears, I'm curious what Vikram is going to say, and so on. So you get the ball rolling, and of course you don't bring them together if you think that there is anyone is feeling any risks for physical harm or whatever. All the things we've learned. So that's that creates a psychological effect similar to the one that nobody wants to appear weak by initiating mediation. It's because of the law. We blame the law or the policy. And then once we are together in the room, the magic is that nobody wants to appear weak by saying, I don't want to discuss. That's the magic. And if you bring Vikram's lawyer and his brother's lawyer or sister into the room, the lawyers will be happy as well, because then they say, okay, we're here. There is a role for us that is acknowledged. And then everyone is happy. And that's what the law looks like in Italy. And it's been really, really successful. Actually, it has creative out of the hundreds and hundreds of thousands of mediations, a massive 86.9 of the mediations that are being organized in Italy. It's only 10% of the cases that go to mediation because, you know, parties want to voluntary, and judge referrals 1% and so on. Contract clauses, ADR contract clauses 0.5. So you see, the massive part is because of the policy. And if it's part of the system, then it's fine. Question is, yes, but is it according to the Constitution? Is it a barrier to the free access to courts and justice and all that? Well, I'm going to put my PhD hat now on. My PhD research is in constitutional law with focus on mediation and access to justice. And it was triggered by a constitutional court decision in Romania, according to which the sanction of sanctioning the plaintiff in this, you know, structure. We had the similar structure, more or less. Issue is that in Romania, the plaintiff that would go to the court without showing proof of complying with this policy would have her or his case dismissed as inadmissible. So a really strong sanction. And the court said, that's too strong. It's not balanced with the purpose being sought. It's not the obligation to attend the first session. That is the issue, is the sanction is too strong. And in Romania, it was not a first mediation session as it is in Italy. It was a first session regarding information about mediation benefits, which is different if you think about it. We didn't have any mandate to sit down with the parties and ask those substantive questions. It was all about process. Should we engage in the process or not? And what are the benefits in the context of in a specific context? So you would provide some information about what could be beneficial in their context. So that would be the scope for the first session in Romania. So the Constitutional Court said that doesn't work, in which case mediation was sent back 20 years, 15, 20 years of different efforts to promote it in Romania and after 7 or 8 years, it's like an apocalyptic, post-apocalyptic, image. It's still like almost nothing. Many lawyers are still saying, "Oh, that was settled 7, 8 years ago. Wasn't it decided that mediation is not constitutional?" So that was the message that was projected in the society. Of course, it was conveniently perceived like that and promoted like that, as one would imagine, as opposed to the Italian model, where lawyers went on strike in 2011 and 12 because the process was mandatory in full, not only this first meeting, but all sessions were mandatory, and the lawyer's role was not recognized at all. Well, in 2013, somebody sat down with lawyers, and I guess it was the Minister of Justice, and okay, let's see what is the royal's role in this context. And now lawyers have to attend all these sessions so that the rights, of the parties themselves are defended throughout the process. Nobody is going to be concerned that the mediator with legal training will actually provide, will actually give legal advice as a mediator, which you cannot do, as we all know. Moreover, mediators without those expertise would not provide legal advice, which is the case in Romania for some mediators that don't have any legal training. They still advise parties. We're going to write this, we're going to write that. I'll tell you that's the way to go. And the lawyers are saying, "What are you doing? I mean, you're not lawyers first. You don't have the capacity to provide this advice. And even if you would, you couldn't provide legal advice. So you have to choose, you lawyer hat or mediator hat." But, so all these things, they have to inform their clients, their presence is mandatory. If they sign the mediation settlement agreement, then that is enforceable, automatically enforceable title. Bar associations get to set up their providers of mediation services. So you see, it was created a system where mediation was not threatening to lawyers and bar associations, and their role was recognized. And actually, mediation is it's better as a service because of the lawyers' presence in it. So now, how many years? Almost 10 years, 8 years down the road, still going, still going. Lawyers are still supporting mediation in Italy. And obviously, as we see, many countries are trying to get this further. Now, I'm not going to spend too much time on this slide, on next 2 or 3 slides, but just to tell you, when we hear mandatory mediation, we have to understand that there are so many dimensions we can define and sliders we can change to change the model, that actually the model will become completely different in different jurisdictions, just to see how many disputes are going to be applicable, only a few or all. Our advice is always to start with a few for 1 or 2 years, monitor, and then decide if you want to go further as a government. What about the initial fees? Will they be paid by the parties, by the government? Would they be set by the policy? In Romania, they said it will be free of charge. So our mediators were like, okay, now it's free labor. You have to do this. You cannot ask for any fee. And there were some 50%, I'm not kidding, 50% of civil and commercial cases. Imagine that. I mean, it was some, and guess what happened? Many mediators started all sorts of creative, solutions to charge not fees, but whatever. And, people are creative, and that created more mess and noise in the system. So anyway, mediation qualification sanction, that is actually the sanction of the invited party of not attending. In Romania, there were no sanctions. So the defendant was free to ignore. Guess what happened? Nothing happened. I mean, it was all a formality, exactly what mediation does not want to be. So we can we can have a symposium, Vikram, only about this slide and different options that we can get to. The sanction for the plaintiff was too strong. In Italy, it's not case inadmissibility. The judge has the possibility to send them back or give a fine. So it's lighter. It certainly not touches the substance of the law. So all these things are really, really critical to actually fine tune the model and find the best solution for different jurisdictions. Okay, now new amendments are being proposed in Italy. Expand dispute types, include fiscal and economic incentives, make sure that because they saw cases where lawyers mandatory was present, so therefore lawyers would attend, but not the parties themselves. And we know as mediators the risks associated with that. People are creative everywhere. So what they're doing, they're trying now to create a clear language according to which the parties will have to be present as well. So we'll see how that goes. Better regulate sanctions in case of absence. So see, they're still trying to improve that as well. Get the public institutions to be part of it. That's critical. I think if governments will be limited to adopting policy and saying, we adopted the policy, but that's for the citizens and the companies, the private sector, public sector cannot use it. Vikram, I use this example. It's like selling toothpaste and not using it. So you have, as a government, you have to really identify solutions to incorporate mediation in the jurisdiction, but also to use the poison, to apply it for your own disputes, because then that will be an example to the citizens, to the private sector, that you believe in this, that you actually use it, because otherwise it's going to be challenging. So I think that's one of the entry doors, and it should be one of the entry doors. Okay, expert opinions brought into mediation, increased the number of training and encourage mediation court referrals. Then new development in mediations. These are things that are being discussed, and I'm going to have a couple of slides, and then I'll look for your initial reflections, Vikram. There are new developments in mediation, use of technology, centralized case management software to actually create apps so that people find it easy to get to reach services and so on, and to reach information about mediation. So, monitoring of quality, sectorial specializations, making sure that each field of practice, each industry sector identifies the best application of mediation. What needs to be done in order to incorporate mediation in their own system. Cross-border mediation, academia, development of the international community of practice. All these things, in our opinion, become relevant. They are not relevant right now because our policy has blocked everything. And since you don't have practice, all these things are not relevant. None of it. So you need practice to have all these things relevant. It's like the chicken and the egg. And practice cannot happen unless you have an enabling policy. So we have to go back to fix the policy in order to get going again. And just one slide about the pandemic lessons and the benefits of online mediation, reduced court simplicity. You can communicate with audio and video with all parties together or separately. You can integrate calendars, make it all accessible. Do not spend time traveling and have even virtual waiting rooms and virtual lobbies. Hello, this is our provider. Welcome. You have somebody waiting for you, smiling and actually saying that our mediation rooms are open. We're ready to take you there. And actually, the main session in a call like this would be the lobby, and then the parties' rooms will be different rooms, and you have somebody in the lobby, just like you would in an actual mediation office. It's amazing what technology can do, and all that can be made secure and confidentially can be ensured. And then you have all sorts of messaging and ways to communicate, share a screen and phone access. Go back to my initial point about our 100 disputes. If we put a mediation step in this context, we are able to get some of those cases that go directly in the court, settle them according to best international practices. We may look at 50 to 75, if not more, % of the cases. And actually less and less cases will go to litigation, and less new conflicts will be created. But that needs to be done with an effective enabling policy and the pre-action protocols, the opt-out model, whatever you call it, the initial efforts to mediation, the reasonable efforts to mediation. There are so many words we can use to actually mandatory mediation, if you will, whatever. It's language. Whatever it's called, it has to be reasonable. It has to use a mild sanction, not to such a strong sanction. It has to be made a part of the system. It has to bring all stakeholders' interests in, and then it will be effective. So that's on that note. I'll just stop sharing the screen, and we have some 20 good.
Thank you, Adi. Thank you. That was very nice, and we could have definitely gone a little longer. Definitely, there is so much to listen to you from, but we'll discuss it as we go along. So basically, I mean, how I look at it is from your discussion that you spoke about the traditional method where the aspect of whether there was some kind of authority figure and how they were doing it, and was it really mediation or not. So first of all, in terms of the definition of mediation, definitely there must have been lots of discussions. But I think the Singapore Convention, that way I like it as broad, but still covers everything and puts it down in a nice way. But one thing I was thinking in the Singapore Convention, it says that should not have the authority to impose a decision. So now we also have to consider whether that is only related to that process which is happening, or is it to a larger context. So what do you think about that?
Well, I know for a fact that there are cases where parties will say, we need our mediator to uh, uh, help us mediate first, and then we just want the decision. We don't care if the same person will, we're not concerned that the mediator will use our vulnerable information that we share against us and all blah, blah. And we don't have any vulnerable information. We just want Vikram to help us mediate. If we don't settle it in 24 hours, Vikram, we expect that you write on a piece of paper and we will be bound by that. That's what we want. So I'm not sure how the Singapore Convention fits within that context. But that's, I think, one example of cases where that may be what parties want. So, and another point I wanted to make, Vikram, is that in order to be effective in many cases, I'm not going to say in all cases, but in many cases, or in order to be more effective, mediation should happen in the shadow of something else. So, for example, if we know that after our mediation, Vikram or somebody else, the judge or the arbiter, will decide, we know that there is a risk that we will lose if this is not going to be settled. If, however, mediation happens and that's it, nothing happens afterwards, neither party is afraid that there will be a scenario where they will have to lose if they don't settle, then at least one party would be interested to procrastinate the situation, to get it going. So my question is, how do we create a system according to which parties are encouraged to engage and to discuss settlement? Just to give you an example, Vikram, I have been working significantly in the past years with independent accountability mechanisms of development banks, such as World Bank or European Bank for Reconstruction and Development, European Investment Bank, and other development banks. And the concept is very simple. The independent accountability mechanisms are independent of the banks themselves, although the banks do ensure their budget. And they receive complaints from citizens and other parties that claim that they were impacted negatively by the bank developed projects. And these mechanisms have the power to investigate the banks themselves and to identify compliance or non-compliance with the bank's policies. And before doing that, these mechanisms are offering dispute resolution or problem-solving initiatives or conflict management, whatever you call it, mediation with capital M, as I call it. And if that, in some cases, if that addresses the concerns to everyone's satisfaction, the investigation of compliance will not be necessary. Do you see what I mean? Mm-hmm. It's just the shadow that makes it encouraging for stakeholders.
Mm-hmm. But I don't know, I'm this whole aspect of the authority figure and everything. What we did was we had this whole concept of ombudsman, which is there in every country, the ombudsman concept. But the point is that ombudsman is again the same thing, the MEDAP concept. So I think that the concept in a way got spoiled. Although you have ombudsman in the US, which are pure mediator, they only will try and mediate and that's it. But here, because we had that MEDA, whether these things actually are going in the direction that we want them to. So I don't know why we have to bring that into these. when the UNCITRAL now in that model of 2018 has specifically said the arbitrator, the mediator and arbitrator should be different people. So I think maybe that part of it, but we can get to that. Let's see. But the faith, I mean, whenever we discuss the US situation, I'm very interested in that part, because in all these years, I've been discussing it in other sessions also, that in all these years, they don't seem to have reduced the number of cases going to court. So the route is court, lawyers, mediation. Are we going to break that cycle? Are we going to have people? Look, you feel that lawyers might be required, and I feel that in India, because every country will be different. In India, whether that is a good thing to get lawyers involved, or is it there's always going to be resistance, and don't the lawyers have so much work with 43 million cases lying in courts, 18 million coming into courts every year? So is there enough work? Will they ever be able to in some way justify mediation? So I just feel that there is something at the grassroots level which is missing. And in a country like that, if it's there for 40 years, what is missing? Why doesn't it develop there, so that you don't have to think of lawyers or courts?
Well, I'll make a, I'm a trained lawyer. That was my second training, but I didn't practice law at all. And I think that there are cases where we don't need a written agreement. A handshake will do. In mediation, I refer to mediation. A handshake will do. I mean, I apologize, Vikram. You say, okay, I'm going to go to the court and just dismiss the case. That's it. We don't need to write anything.
Yep.
So these are examples where legal advice is not really needed throughout the mediation process, before, during, after. So we could imagine cases like that. But Vikram, there are many cases where without legal advice, parties would not make informed choices. It's about understanding the legal consequences of the options they have at hand. The question is, if you as a mediator, if you have the legal training yourself, is it your role to explain those legal consequences to parties in dispute? I think that may be challenging, because if both parties would have their lawyers, they may explain different things. You see, it's how they interpret the law to support in the interest of their own clients. Of course, you could provide a neutral interpretation of the law, in which case you would not be providing a mediation service, you would be providing a mediation service and combined with a neutral expert determination service,
Yeah.
right? Which is fine if this is what the parties want and need, and if they trust you, that's fine with me. But we have to really understand that there are countries like Romania where, in order to provide a neutral expert determination, legal advice expert determination service, you need a contract according to which you provide that legal advice, because that's how you are accountable to the advice you're providing. And guess what? In Romania, you cannot sign a contract as a lawyer with two disputing parties that have opposing interests. That's on one hand. On the other hand, it's specifically mentioned that it would be a conflict of interest to be both mediator and a lawyer for parties with the opposing interests. So if you ask me, I think these are things that should be discussed with the Bar Association, the lawyers, and the policymakers, and the academia, and experienced mediators, get them all together. Folks, let's wrap our heads around these, concepts, and really see what are the best ways going forward in a jurisdiction.
But I'm just thinking that when you say that policymakers should sit down with people to discuss this, is the user part of it?
No, I think users should be at the table as well.
Exactly.
Consumers, the private sector, absolutely. They're the main stakeholder.
But that is what I see missing. At least in India, we were discussing this whole draft mediation law, whether the user was represented or not. And of course, I see that judges, lawyers who are maybe looking in some way running mediation centers in courts. I'll talk about that, of course, separately. And institutions who have a vested interest maybe in the training aspect of it. When these are the only people that advise the government, is that policy going to be something which is workable or is and benefit people, or it will just benefit a few? So that, I mean, we'll have to discuss that. I mean, that's also a discussion point. But I think what basically, I think what one thing that you said is that in the, of course, you were talking about the mandatory mediation, that the taste of it, to get the taste of it. I just feel that I don't know about how the things in community mediation in Romania are happening, but I thought that that level, the taste of mediation would have been a good thing to have for people to have. So is that working out there in community mediation?
Well, we don't know because we don't really have a mechanism to monitor. What we do see, and we've been discussing about this, Vikram, is that more and more people move from the rural to urban areas, which means that traditional methods are fading.
Yep.
Those trusted citizens, it may be, you know, an elder in a community to which everyone used to go to. That community has less and less people right now, and there are less and less trusted community members where everyone go to, and those processes are fading out. So that's documented because the more and more people live in the urban areas, but still a good percentage of people still live in rural areas and are not planning on getting to the city folks, to the nice city folks with suit and tie, pay them a fee to to be sat down and to have their neighbor brought from the countryside again so that they sit down and discuss about mediation. They would prefer that free of charge at the corner of their street where they used to do that. So perhaps we need to identify those trusted community members and top up their skills. And we've been discussing about this. So going to your question, Vikram, we don't know because we don't really monitor.
Mhm. Because when I'm looking at this, exactly what you said, in a country like ours, about 60% is still rural population. So something is working for us, because in a country of 1.3 billion people, only 18 million matters go into court. I was looking at one, I keep talking about in every session, I'll to say it again. I did a Google search on the US. One search gives me 100 million cases going into courts every year. Whether that's right or not, because I see another Google search gives me something else, but that I definitely will have to look at. But if the one gives me 40 million also, in a population of 300 million, if you have 40 million cases going to court, is as good as about 180 million cases going in India, more than that. So we are maybe we're doing something right. Maybe we have to learn from there, and maybe the way mediation has developed, maybe the US model has gone out. Maybe there's something fundamentally wrong in that. I mean, we should question it. I'm just saying we should question all that and not take it as okay, this is how it has to happen, because maybe it hasn't worked in that place. But the concept of mediation might be used a lot. The word might be used a lot, but is it really working? Is that in 40 years, if people are first of all still looking at the court as the first option, that means the culture of mediation might not be there. But maybe as a culture, they might be different. Maybe it's a different. Individualistic societies will develop differently and all.
Right.
I think that by itself, like you said, I think we need lots of these symposia. A lot of things have to be discussed. But quickly, do you think you can also touch on the Bound Conference, because you're the first person who has mentioned it in the symposium? Do you want to just quickly talk about it?
Yeah, sure, absolutely, very shortly. What I would say before I do that is we have to really understand, as you said, what are the mechanisms that are being used, and if the courts are the first option, I think we have to understand that for some cases the courts are the culture and the tradition. So I would put that as part of the culture. I would not put the courts or the litigation outside the culture. Uh,
So interesting topic comes up for the next symposium:
yes,
litigation in our culture and traditions.
yes, because I go out in the street right now and I ask folk, what do you think about where would you go? And they would say I will go to the court with me, which means it's part of the culture. Anyway, Pound Conference, I think it's if not one of the most significant research and survey studies and worldwide study. It's certainly a huge one. Basically, the same set of questions asked in different meetings all around the world to really understand how providers of services, users of services, advisors that are advising the users, referrals that are proposing this, like judges, for example, or influencers like policymakers and educators, how they see mediation and how they would prioritize different options for next steps. I think that the world has a lot of data now, thanks to the Pound Conference survey. Maybe Vikram, if you can share the link with your audience, that would be very helpful, because the data is there. It has been published. It's available for everyone, and I would start there when it comes about really designing an effective mediation policy, because it has a lot of wisdom in it. Really a worldwide effort that needs to be praised.
But the other thing, you spoke about the 1998 and the concept of mediation in terms of law and other things to being discussed. I just feel that India was far ahead of its time. That we, of course, called it conciliation because the UNCITRAL was calling it conciliation. But we, according to me, have the perfect. Still have the perfect fit. You have mediation as in an informal process. You get a contract at the end of it, which, like you said, it could be a verbal contract. Contracts can be verbal also. So that part of it. Then you have conciliation, a formal process, everything laid down. But there it has to be a written settlement agreement, and then becomes as good as a court decree. So I think we should even look at that, because maybe we are right now discussing it from certain jurisdictions where actually it might not even have worked and might change something which we haven't used. Imagine, we might have been the best, but we haven't used it. And I think we'll have to definitely discuss that. But tell me, in terms of I mean, at this point of time, can you really say that the culture of mediation as such is there in Romania? I mean, what would you really say
Yeah,
as
of
the
course.
people
Yes,
actually?
it's there. It's there. It's only that needs to be nurtured. It needs to be developed. I think if we go back in history, we will see that, for example, I think back in the 60s or so, during our period after the Second World War, we had the conciliation committees next that were established, for example, for factories that had, I don't know, like 200 employees, like many employees. And these conciliation committees, they were like, they were supposed to mediate. And when they introduced mediation in Romania in 2006, everyone said, but we had these things like 50 years ago or 40 years ago. And everyone said, yes, we had them. And I looked, okay, let's see. You know what those committees did? They used to decide matters. I mean, they used to say, you do this, thank you very much. That's it.
But one thing, Adi, free and courts and mediation, this connection has to go. And how are we going to do that? Because everywhere still we are talking about, even in, I don't know how much these people in Italy are paid, the mandatory mediation might be there, how much is paid to the mediators. So I just keep saying this, that if the mediators do it in courts and almost free, a person like me or you who are doing only mediation, every time they do pro bono, they're actually affecting someone's livelihood. Every day they're doing that. And how do we develop only
Well,
mediators? That is only practicing as
well,
mediators. How are you looking at that?
the question is, Vikram, is how do we create a system in which services can be provided pro bono when needed in a way that will not affect the situations you mentioned, where you have private mediators and so on. So, for example, you may have legal aid policies that will regulate who is eligible to receive services pro bono, and you could limit, for example, even if you're a professional mediator, you must provide one or two pro bono cases per year for people in that would fit this description, situations where parties will not have the income and so on and so forth. So that's, and I hear you. I mean, that's critical, because when you have all services provided pro bono in the courts, of course you prevent professional
Yeah,
services from
exactly.
developing.
Yeah.
In the I hear you totally. In Italy, what they did for it was to put it in the policy so that nobody would abuse the system. They would put in the policy the fee is 40 euro for cases up to some level, I think 200,000 euro, and 80 euro per party for cases above 200,000 euro, just for the first meeting. And then the mediation fees are regulated in case the parties would go with the full process. So you see, the policymaker said, okay, let's make this accessible, in which case we'll define what accessible means within our jurisdiction. In Romania, the Romanian policymakers decided that accessible is free of charge. Thank you very much.
Okay, now we're eating into Yemi's time. Let me just introduce
Yes.
you to him first. Good morning, Yemi. You want to?
Good morning. Good
We are
morning,
now.
Vikram. Good morning, everybody else. I hope you can hear me clearly.
Yeah, perfectly all right. Have you
Yes.
met Adi before? Have you met Adi?
No, but I've been very intrigued by some things he said, even though I wanted to be a little cheeky to say that, well, if the courts have become culture, then the parliament is culture, then the Congress is culture, then institutions. I think we need to distinguish between institutions
We'll take it up,
and
yeah. Yeah.
yes, I
We'll take it
know,
up in
I
your
know.
session. In your session is going to be it'll be a different session altogether. I'll have to
No,
stop
no,
this
no, no,
recording.
don't take me too seriously on that.
No, no, we have to
Good to
take
good
we'll
to
have to
meet you.
stop this session and then start your session. I'll just do it. I just thought
Okay, all right.
can we take 2 minutes before we start your session? It's your time right now. And we
Take
have
5 minutes.
okay, but we have to give you the full hour, 1 hour. So just give me 2 minutes. Was one thing that I want to make a statement on this aspect is that Adi, are we actually funding people's disputes? When the courts say that a lawyer, like in India, a lawyer has to have at least 10 years of experience to be in the court system, and he gets $10 a session. What are we funding that thing? You have a court system, you have a mediation center, a lawyer providing it. So why are we funding people's disputes?
How much time do you have, Vikram?
Okay, forget it. Which answers
How
my
much
question.
time? That is that feeds into the it starts with the public funds and the public budget. Just to give you one example, and then I'll stop. And it's great to meet you, Yemi. And I see my friend Giovanni here. Lovely to see you as well, Giovanni. In Romania, they had incentives according to which the government will give you a full refund of the court fees in case you would settle.
Here also, yeah.
Yeah, they took it out. And they said it will do it 50% and not when you settle around houses and lands and so on, because that's a different story. And I spoke with the people in the parliament. I said, why did you take them? And they said the government was losing money.
Exactly.
So before we ask and think about the funding people's disputes, we have to look at how do we spend the public funds? And
Exactly. That's what I'm
I
saying.
think that's,
Exactly what I'm saying. Why should the
yeah,
taxpayer be paying for it? But in India, what we've done is at least one thing, good thing is, of course, the court system, even there, if they settle it, it gets refunded. But at least now the Supreme Court gave a decision that if you settle it privately also, even then it'll be refunded. I'm happy on that. I'm happy on that, that you don't come into the court, you stay away and you settle it. That's one aspect of it. But good thing you spoke about the new developments, because like I told you, Colin Rule is coming on the 9th, and we will discuss all the new developments and everything with him. So thank you very much. Very nice of you. And obviously, it's always a pleasure speaking to you. And what I'll do is let me end this session here, and then we'll start the next one, and we can just hi say to